So I was asked the question, I received some paperwork, a constable came and delivered paperwork to my door and to me. I don't know what it is. I don't know what's going on. He said to read the papers carefully. I'm reading them. I don't understand them. What typically that is you've probably been served with what is called a summons and a complaint. So I have here a draft. This is a sample form of a summons, and you'll see right here it says summons right there. So this is how to read a court document. Typically you'll have the plaintiff or the party who's drafting the document right here. You'll have the court information right here. You'll have the plaintiff versus the defendant right there, or sometimes it's the petitioner and the respondent, or sometimes it's the appellant and the appellee. Over here, you'll see in bold the name of the document. This is always the title of the document. This right here is called a caption. This right here tells you what it is, a summons. It'll have a case number, the judge's name. If there's a commissioner, there'll be a commissioner's name. And then you just start reading right here. Now, this is a bilingual notice. So on this column, it's in English. In this column, it's in Spanish. And you just need to read through it carefully. Typically, when you get a summons, you need to file a written answer to the complaint. So the way a lawsuit is started in the state of Utah is it started with a complaint. The complaint is a short, brief statement setting forth the causes of actions or the claims that the plaintiff has against the defendant. So if you've been served, if you've received these, you're likely a defendant. Or there could be other things you would be served with as well, but for sake of simplicity, you're probably a defendant in case if you've been served with a summons and a complaint. Okay? When you get the complaint, you should read through it. If you're not familiar with, obviously if you can get an attorney to help you, that's really helpful. And the reason attorneys are helpful is because we deal with this stuff all the time. I can't tell you how many summons and complaints I've either drafted and filed myself or I've responded to by filing an answer. So whenever there's a complaint, the number 2 document is an answer. And that's typically what's filed. Sometimes a motion to dismiss is filed, or some other type of motion can be filed. Sometimes it's simply contacting the other party and starting settlement negotiations. So there's many different ways that a case can go forward, but I want to explain to you the basic outline of a case in Utah. So it starts with a summons and complaint here. Summons and complaint. You're served with that. If you're served in the state of Utah, you have 21 days to file your written answer with the court. If you're served outside of the state of Utah, you have 30 days typically to file a written answer with the court. If you don't file a written answer, a default can be entered against you. A default means the other side wins without having to go to court and prove their case. It means because you failed to respond, you've admitted by your failure to file a written answer denying those things that they are true. That's the way the law works, whether we like it or not. So the next step is typically to file an answer. When your answer is filed, typically the court will then enter what we call a scheduling order, or nowadays they call it a notice of event due dates. What a notice of event due dates is, it gives you dates where certain things have to be done. The first thing I'm going to put here, I'll just put scheduling order, because scheduling order sometimes makes it easier for us to understand that it's a scheduling. It's the thing where certain things have to be done by a certain date. So after the scheduling order is entered, typically it's 2 weeks after that scheduling order is entered that the plaintiff's initial disclosures are due. And that's under Rule 26. So you want to read Rule 26. It's going to set forth all of the things that the plaintiff needs to disclose or provide to the defendant. And then typically 4 weeks after that, so we're going to go down this way, 4 weeks after that, the defendant then has to file their certificate of service of initial disclosures and serve the other side's, defendant serves the plaintiff, with their initial disclosures. And then the next step is the discovery process. There's 2 types of discovery. There's fact discovery, and then there's expert discovery. Now, I'll write that out. There we go. So fact discovery and expert discovery. Fact discovery is all of the witnesses, so the people who have actual first-hand knowledge of the information of the events that have taken place. Experts are those not always used in cases, but sometimes to say that this is what should have happened in the case, or the expert, for example, on a medical case can say this is what the doctor should have done. An expert in a contracting case can say the general contractor should have done these things instead of these other things that were done. Or they're simply used to bolster the case. Handwriting experts have been used to say this signature is a valid one and it's authentic and original. And another handwriting expert could also say, no, this is a forgery, this is a fraudulent signature. So after the fact discovery is over, after the expert discovery is over, and just so you know, discovery includes written discovery, so that's interrogatories, request for production of documents, or request for inspection of some things, and also deposition, so you can bring someone in and depose them. So both fact and expert discovery. When those are done, you file what's called a certificate of readiness for trial. Certificate of readiness. And the certificate of readiness for trial tells the judge, hey, we're ready to take this case to trial. And the court will then schedule, the court clerk will typically schedule what's called a pretrial conference. At the pretrial conference, you meet with the court and you need to have your calendar ready and you schedule a time with the court to have a trial. How long is the trial? Will it be a jury trial or will it be a bench trial, meaning the judge is going to make the decisions? Well, back here, when you filed the complaint, you should have identified that you want a jury if you want to pay for the jury. Remember, we're talking about a civil case, not a criminal case. In a civil case, there is no right to a jury. You can, of course, pay for one and ask for one, and the court can grant you one. If you don't ask for it, you don't pay for it, you don't get it. It's going to be a bench trial before a judge. And then after that pretrial conference, it's abbreviated PTC, then you're going to have a trial setting. And that trial, depending on your case, the attorneys will typically want either half day, a full day, 3 days, done one for a couple weeks. It really depends. Some cases go on for months. It really depends on the amount of witnesses, the amount of evidence that you're going to put on, and then the other side. So if you're the plaintiff, you're going to determine how much you need, and then the defendant's probably going to determine how much they need. So if each party needs a week, that means it's going to be a 2-week trial. If there's an interpreter for whatever reasons, like say someone speaks Chinese or Tagalog or Spanish, and you need to have an interpreter there, it's going to double the time for the trial setting. So 2 times, because everything that's spoken is going to be said at least twice, sometimes more. So that's typically the start to finish of a civil case. Start and finish of a civil case in the state of Utah. At the end of the trial, the judge makes a ruling, and that ruling becomes the order of the court. Now, there's always, of course, you've heard of the word appeal. We're not going to talk about appeals today, but know that that is an option. But in order to appeal, you can't just say, I disagree, so I'm going to appeal. You have to have a foundational basis for your appeal. You can't just say, I didn't like it. Anyway, I hope this has been helpful to explain to you the lawsuit process in the state of Utah. If you have a question, feel free to give me a call. Thanks for watching.